going back to the, if it's, you know, well-being of children, if it's best interest of the child, it's on both sides, right? Like, if we don't feel like that there's a pathway back to that biological family, then we need to move toward another permanency goal as quickly as possible. So we need to equip our workers to have, and our parents, and you know, to clearly explain to them, this is what you need to do to reunify with your kids, and we're tracking that. That's very clear. And if they follow it, right, then even if we do have a judge that feels like they've moved the mark, at least I can feel good that our workers have done what we can do and say, listen, we filed this, we feel like the parents followed that, and we can bring that up when we talk about what filings have happened. I just wanted to say that is something else that we're working on, and you will see a rule filed on that process.
Okay, we've got other people who would like to make comments before we do. Representative Chris Dinkins has just entered the room, so thank you for being here, Representative. Yes, ma'am.
Well, I think one part of the solution to make things better is what the gentleman alluded to, the unique system of Missouri. It's the only state that has the dual system with both Children's Division and Juvenile Officer, which takes away the role of a judge as a neutral. Our judges in these cases are not neutrals. The juvenile officer reports directly to the judge. So that changes, the situation. The other thing that would...
Sorry, I was just gonna, and so there have been some changes, and it's not quite accurate to say that Missouri's system is completely unique. There are other states that have similar removal processes and things as we do
Good.
here, but there is a separation. There's a Supreme Court rule that requires the judge that's hearing the cases is not the judge that is involved with the juvenile officers. There's separation in that regard. So there have been some efforts to make sure that there are some protections in that regard.
Well,
But can I bring
I
up
would
one?
refer to you Missouri Law Review entitled "Where the Judiciary Prosecutes in Front of Itself, Missouri's Unconstitutional Juvenile Court Structure." I have a few copies with me. This duplication is really kind of wasteful. If Children's Division is making these efforts, having the juvenile officer also removes the possibility for the Children's Division to have a real impact.
I think it's important to know too.
Simplify and improve things at the same time.
I think from some perspectives I've heard is like, well, the juvenile office and the Children's Division are always on the same page. But we have data that supports the fact that is not necessarily the case. And I think the strength in our system is the fact that you have a number of parties that are involved in that decision. Because I will tell you, there's been, people kicked around, there's ideas kicked around saying, well, should we just allow the Children's Division to make decisions on removal? And my response is, I don't want that. Like, I feel like it's important for there to be a team, a team decision that because there is. I mean, we can have all the standardization in the world, but we know when we're talking about the issues that we're talking about, you can't help but bring in bias on how you think about situations. And so that's why I think the power in our system is you do have several parties that's looking at that case and making a decision, and it's not the responsibility of just one organization.
So I think one of the ways to think about that is, the decision to remove a child from the home, from a family is an awesome power that should be exercised only in appropriate cases. And it is something that should be used rarely and should be used when children are imminent, in danger. And the way the Missouri system is set up is that it creates some checks and balances. It doesn't make the system easy or sometimes efficient. But when we're making these really difficult decisions that can affect a child and a family for the rest of their life, the framers of our Constitution developed checks and balances. And I think that what the Missouri system here is we do the investigation on the Children's Division side, but we can't remove. We have to go to the juvenile office, who independently, and I will tell you we have plenty of arguments back and forth as to whether or not a child should or should not be removed. I was just talking with one of my lawyers last night who had a 5-hour adjudication hearing against the juvenile office in another county, and our position was the child should not be removed. The JO's, and the court actually ruled in our favor on that one. So I think there's been a lot of discussion along that, and I know which law review article. In fact, I know the author of the law. It's actually a very interesting article. On the other hand, the idea when you have checks and balances, it should not be easy to remove kids from families, and there need to be checks and balances to make sure that, and when you have checks and balances, it helps make sure that that we're maybe making the right decision. And in cases like this, when you're making these enormous decisions involving children and families, we expect people to disagree, and sometimes disagree loudly and argue back and forth. In the end, we need to be respectful and through the court process. But my view is there are very good reasons why it is appropriate to have that check and balance. Now, I can argue the other side of anybody, but I think that's maybe what you're.
And I think it's a great thing for you to bring up, and I appreciate the opportunity to, just sort of clarify some things that has been looked at a considerable amount of time on that previously.
Can I say something? Yeah. I think in the law review article that you brought up was a very good point, and it was a very excellent law review article. And I am focusing on a term that Vonne used earlier, which is incestuous, okay? Our system is incestuous, despite the fact that the law's changed recently, and now suddenly we say, well, we're gonna have another judge who is in charge of the juvenile office, and we're going to say only that judge is in charge of hiring and firing juvenile office people. And now this judge who's been hiring and firing juvenile office people for all these years, we're going to pretend that they don't have anything to do with that system anymore that had been in place for, decades, okay? We're supposed to pretend that this judge who's making a decision and is supposed to be basically listening to the juvenile office, which is basically like a juvenile prosecutor. And if we're supposed to believe that there's, not this incestuous relationship between the Children's Division and the juvenile office and the actual court system, in our circuit particularly, that's crazy. It's a horribly incestuous system here. And what that does is basically set up a situation where the litigants in the system and the defense attorneys who are involved in the system go into any court hearing immediately feeling like they don't get a fair hearing. Is anybody listening to anything that's going on? And if you have, and then the nature of the system is that there's going to be a lot of families who sometimes there's nothing you can do. Okay, that's just the nature of the system. But you don't want to go into court immediately feeling, before you even argue, before you even talk about anything, immediately believing that it's unfair and it doesn't matter what you say. And it doesn't matter what you argue.
What would you do to change it?
Well, in our circuit, right now, we have a number of juvenile office employees who are chosen and hired by a judge who is the juvenile judge. And those people, in part, are sometimes, and the people who weren't fired and pushed out, the people who remain are people who would just basically do what a certain juvenile court wanted them to do. And despite us now saying, well, there's another judge in charge of the juvenile office, it still remains that you have those people who are still here, who were chosen and trained by a juvenile judge. And those people haven't disappeared, they're still here. And you still have a contract guardian ad litem's office who were also chosen and hired by a particular juvenile judge. And despite us saying that, well, now another judge is in charge of it, you still have that system in place. You still have all those people in place. And they're still basically going to mostly agree with each other. I know Children's Division does not always agree with the juvenile office in this circuit. And for a long period of time, the Children's Division actually required their own attorney down here, which is very rare in the state of Missouri. And I think that it basically just highlights the specific problem we have in this circuit. If the Children's Division required its own attorney for that long of a period of time, we have a problem in the circuit. And you don't want to go into the system immediately feeling like there's nothing that you can do for your client, that it's inherently unfair and there's nothing that you can do.
Is this one of the circuits that has fostering court improvement through OSCA?
Not to my knowledge.
Do you know what that program is?
Well, no.
Yes, so, yeah, and, you know, just to sort of talk solutions, and I'm watching the clock here, you know, so some of the things that are in the works to go back to what the issue you were raising about being a part of the conversation.
Right.
So the next aspect of the thing we're jointly working on is to train facilitators to actually hold local meetings, partnership meetings. You know, I hear people talk about collaboration, and I always say I don't think that's enough. I think you need to truly be partners in this process, and it requires an investment and, you know, to sort of get to those outcomes where things work. But to develop those local partnerships, like fostering court improvement, where everyone is at the table. So, you know, we have some juvenile judge training coming up. I said to Mary, after we met last week, one of the things is we need to do more training for the folks around the legal issues, and so that will be something that we work on. And then we're going to come out and do sort of regional convenings and bring folks together. So those teams from the local circuit to have these really difficult discussions and get the people in the room to have a facilitated, appropriate discussion so we get to those things that everybody is aiming for in the process.
Dale, can I say something? I've heard a lot of lawyers talking, I've heard a lot of staff talking.
Yep.
We've got some other people in the community that have come.
Well,
apparently it's just me. And I'm sorry, I've never been in the system, I've never had an experience with the system, but what I'm hearing from the outside of the system, from foster parents and a person who tried to be a foster parent that was treated extremely badly by the local office, is what I'm hearing, and you've even admitted to it, and I'm sorry to say this, but you've admitted to the lack of education, you've admitted to the lack of training, you've admitted to the fact that your employees have hostility walking into an environment. How can that make any situation better? And I apologize, I'm getting hostile myself just thinking about it. And then also the feeling of power by these employees who walk in, who are public servants, and they have a position and they have a job to do. I'm sitting next to a person who is in the medical field that made a recommendation, as an attorney did in fact, to one of your caseworkers who was completely ignored. And that's all I wanted to say. We definitely have a problem if and when you set up this coalition or whatever it is, contact me, I'd love to serve.
Well, I hope it says something by the department that I came to listen, right? Like I can't, the bond, and I'm not saying, I know everything's not perfect, you know, and I have made a commitment to Monica Hogue, who kind of oversees the Southeast region, and I will have these conversations with her, and I will provide that feedback. But you know, I don't want to make excuses, but I also want to say that, you know, we won't change the system overnight. So, I mean, these conversations are important. I feel like we are moving in the right direction, but also in the meantime, there are opportunities as far as, you know, there are ways that a parent can appeal up to our Children's Division central office. There are ways that a foster, there are processes.
Service delivery grievance.
Yeah, there are grievance processes that I want to make sure people are educated about, because quite frankly, since I've been in this meeting, I'll be asking, you know, once that I've shared that information, one of the things I'll be asking is, I'd like to see what grievances we're getting from this circuit to understand, are people taking advantage of the process, and do I see, a higher amount of grievances maybe coming out of a particular circuit now that we've communicated that. But I would encourage people to use those processes, because they aren't there just for lip service, right? There's they need to be, we need to use them, because that's a way for me to understand and know what's happening. Because honestly, if Representative Wright would have never reached out to me, how would I have known how this community was feeling unless I was seeing, things through that data, so.
Right. And I want to thank you for coming here. I agree, and I know that you recognize the importance of it. But the reason that the grievances are not being sought is because these children are being hung like a carrot, and they're dangling over these families, whether it be the foster families to do the right thing and what the caseworkers wanted, or the other people. They're being hung around as a carrot. That is not in the best interest of the children.
Well,
And
it's
that's why
not,
the
but,
grievances-
but I think I want to be clear on the fact that, I don't want anyone to feel like that. And the next step, the next step is the grievance process needs to be used, because there are ways, just like with our own staff, that say, I'm afraid to speak up about my supervisor or whatever. Believe it or not, there are ways for me to find that out, and if I find out that that is happening, then there will be, so that's where maybe we need to have more personal conversations that we can't have in a large setting. If you wanna share information with me about particular cases that I won't share publicly, I can't, but I can certainly take those back and work with our attorneys around making sure, because one of the things that I do, frankly, is if I get a case that rises to my level, I'm gonna go right to Children's Vision, I'm gonna go to my general counsel, because Mark's gonna tell me what he thinks is the right thing to do in that case, and whether we've done the right thing or not, from our
And the fact that
perspective.
you're here today tells me that is in fact the truth. And since Vonne had actually stepped out of the office when I said that, and perhaps I may be the only one in the room that feels that way, do you agree that the children are being dangled around kind of as a carrot?
Oh, God, yes.
Okay, so
Oh,
nobody spoke up when I
absolutely.
said that, but I mean, I honestly believe it, and I'm hearing it from
Absolutely.
every side of the services, that that's kind of what's being done.
What does that mean when you said dangle like a carrot?
I'll
What does
give
that
She
mean?
explained it just a
No, no,
minute
no,
ago.
I mean, I wanted to, what?
So, you're gonna file a complaint with we're not even gonna tell you how to file a complaint, because if you do, we're gonna jerk those children out of your home. If you don't do, like you said, when you're speaking with a parent, they're basically just being hung there. That is what is not in the best interest of the children.